Apologies to the other venues. We've just had Echuca join us. We're very excited. We've got quite a large number signing in from a remote location up at Echuca. So apologies for that delay, but it's great that we've got them joining us today. So I was just at Echuca just introducing our two speakers today, Paul Geyer and Sarah Jane Christensen. Sarah Jane is a lawyer with over 20 years' experience in the provision of legal and public company secretarial solutions for leading corporate organisations. Sarah Jane advises on legal and governance issues for boards across all sectors, with a particular focus on the not-for-profit sector. She was formerly a senior fellow at Monash University, lecturing on directors' duties and corporate governance for postgraduate law students, and accredited facilitator with the Australian Institute of Company Directors. Sarah Jane has been a non-executive director on the board of Cougar Energy Limited and vice chair of Carey Baptist Grammar. She is currently a non-executive director of the Australian Business Volunteers Limited and a private family business. So we're very excited to welcome them both here today. As I explained, if all venues could have their microphones on mute just to assist with limiting the feedback loop. And then after the speakers, we'll actually go to question time, and you can actually text your questions through to that text number coming up on the screen. I'll just repeat it one more time just before we go to the speakers. 0427 659 140. And with that, I'd like to introduce Paul Geyer, who will be our first speaker.
Thanks,
Welcome,
Sally.
Paul.
Thanks, Sally. I might say right from the outset, I grew up in Sunny Cliffs, which is just on the outskirts of Mildura on a fruit block. So talking about regional Victoria and places like Echuca being remote, it doesn't actually feel that remote to me. It feels quite normal. And many years ago, I was doing a site visit of GP clinics in the UK, and I visited a GP who was 26 miles from Sheffield, who described himself as a rural and remote GP. And I thought, 26 miles, that's probably from Melbourne to Frankston, hardly remote in the scheme of things. But this sort of shows you that being regional often is a state of mind, and I can see this technology certainly narrows the distance. Our aim today is to give you a really broad overview of directors' duties and talk about some of the interesting things that are occurring in directorship and some of the changes that are underway, and some of the sort of housekeeping things that you might want to think about for your boards. I'll say right from the outset, governance is a surprisingly complex topic with lots of grey. Any particular area of governance, such as the legal aspect or the accounting aspect, is a body of knowledge in its own right. So if you've got any issues at all that this presentation pops up in your mind, you should think about seeking proper technical advice rather than using our overview and generalised statements as really thorough guidance for your particular situation with your particular board. So to really start, a director holds a position of accountability. It surprises many people, but there are over 500 laws that deliver personal liability to directors for corporate breaches. There are 500 laws is an extraordinary number, and it probably defies most people's ability to actually understand their full breadth of responsibilities given that many laws. But it's this notion of being held to account for corporate breaches which troubles many people, that something can occur in an organisation that you're a board of, that you have no understanding of, no knowledge of, but still be held personally liable for. And it creates a lot of pressure on directors to perform. But one of the fundamental notions of being a director is about being a fiduciary. And it defines what a director's role is and the board's obligation. And I think one of the nicest quotes about a fiduciary, I think, is that last quote, which comes from Jane Walton. Fiduciary duty requires one of the highest orders of thinking, beyond thinking and doing for self, thinking and doing for a close group, family, friends and other entities. So really, it is moving into this area of ethics, and if you can apply an ethical framework to being a director, It will assist you with your accountabilities. The word fiduciary itself comes from Latin, meaning faith and trust. Right, very important concepts around faith and trust. These are the summary of duties that come straight out of the Corporations Act. Obviously, fiduciary right from the outset, a duty to act in good faith in the best interests of the company, a duty to act with care and diligence, not to make improper use of information, not to make improper use of position, to avoid conflicts of interest, to act honestly. You sometimes wonder why that particular one has to be stated, but clearly it's needed. And to not trade while insolvent. And of course, trading while insolvent can lead to criminal punishments. The important thing to look at when you look at this summary is that these aren't particularly complex notions. You know, my 11-year-old son can get his head around most of these dot points, while I'd probably have to explain to him what insolvent trading is. But the first dot point around acting in good faith, and only in the interest of the company, is something he can understand. So these aren't particularly complex terms, and they really do form the foundation of most board roles. I usually say that if the Corporations Act doesn't get you, common law will. And the common law requires that a director must become familiar with the company's business, monitor the company's activities and policies, and maintain familiarity with the company's financial status, including by regularly critically reviewing financial statements. The recent case with Centro really highlights this last point. It requires all directors to be able to read financial statements. It doesn't assume that every director has to be an accountant or has to have a detailed understanding, but it assumes a basic understanding that everyone sitting around a board table can review the financial statements and do that with a critical and independent mind. One of the issues that we see coming up a lot, and we get lots of questions about from members and also non-members, is around conflict of interest. And I like to begin it from a particular point of view, which is around the notion of being independent. And this quote, I think, is really appropriate. And a non-executive director, I've used the acronym NED, a non-executive director is free of any business or other relationships that could materially interfere with the independent exercise of their judgment. If you're following what's going on in New South Wales, you see this playing out where suggestions are being made that some politicians have lost their independence because they're being too heavily influenced by gifts or favours given by lobbyists. The ASX Corporate Governance Council is very clear about this. Directors must act fairly and impartially, avoid bias, discrimination, caprice or self-interest. And you can see the basis of this comes from the Corporations Act. You sit on a board of a company and only act in that company's interests. You're not there to act in the interest of outsiders to the company, a particular class of shareholders, or a particular group of shareholders, or in not-for-profit's case, a particular group of members. You're there to act for the whole organisation and its best interest. The next quote comes from the State Government of Victoria, the Victorian Public Entity Directors Code of Conduct. And it goes to a little bit more detail. Do not use your position as a director to seek an undue advantage for yourself, family members or associates, or to cause detriment to the public entity. Ensure that you decline gifts or favours that may cast doubt on your ability to apply independent judgment. And the last Premier of New South Wales probably fell foul on that concept. I like to think about this in not-for-profits as being a little bit more complex than private companies or commercial companies. Because in commercial companies you're dealing with financial interests, and often that can be very easy to be clear whether or not someone's actually going to financially gain or lose from a particular decision-making process or decision that's underway in the boardroom. But of course in not-for-profits, when you're dealing with issues around mission, role, members' interests, who benefits from the not-for-profits activities, it's beyond money. And so you really are at the heart of around, is someone sitting at the table with an independent mind, or are they being unduly influenced by others around them? So the issues around conflict of interest often settle around how you should handle them. But also around a related notion around conflict of duty. If you're on the board of two organisations, if you're a director of two organisations, you have a duty to both, to act only in the interest of one. So when you're sitting on the second board, you're now conflicted between acting in two interests when they start to overlap. This often causes a challenge, and you can see that second point around being a representative, that you can't be a representative. You can't represent organisation X on organisation Y's board because you have a duty to only act in the interest of one organisation's board. And there lies the great challenge of being a representative. And fundamentally, you can't sit on a board acting as a representative. So the process, most boards will maintain a register of interests, of commercial interests of their directors. The standard thing is that when you declare an interest that you exit the room. But I think there's some sub-points in here which are really important to understand. As soon as a conflict has been identified by a director or someone else on the board, it must be disclosed. Transparency is absolutely essential. The beginning point of trust is around open disclosure of when you think you're losing your independence and your judgment could be swayed. But the last point from Simon Longstaff from the St James Ethics Centre is key. The moment that an individual director discloses they have a conflict or they are no longer capable of exercising judgment, they are not the person to decide how it is to be resolved. It's the others around the board table who decide how that conflict is to be resolved. And you can see, when you look at the bottom part of this slide, there are some options for how the board can decide a conflict is to be resolved. The director could leave the room. They could stay, observe, remain silent and not vote. They can contribute and then not leave, and so on and so on. But it's important that the board decides, not the individual who is conflicted. So on that note about conflict of interest, I might hand over to Sarah Jane.